second certainty you need to be thinking about is certainty of subject matter. And this is one where there is quite a lot of controversial case law, and you need to be aware that Hunter and Moss, which is one of the big cases, re Goldcore, re London Wines, they're actually all quite controversial, and they've been criticised a lot, and different academics and other judges have different opinions about how they should have been decided, which is why it's quite fertile ground for an essay question. So you need to be looking into those, and definitely read your textbooks on the commentary around that area. Remember, it's fine as well if your textbook gives a certain opinion about whether or not Hunter or Moss was wrongly decided, for example, you can cite that academic in an essay. You can say, depending on who it is, if your textbook is written by Mr. Smith, you say so-and-so Smith believes that Hunter and Moss was wrongly decided for these reasons. And that is an academic opinion. It doesn't just have to be from essays. You can use your textbooks instead. Be really careful with that you don't just have one textbook that you quote all the time. If you're going to be using that as academic commentary, then you should probably be taking it from different sources. So if you've got different textbooks, you need to be swapping them and reading them. So there's two different types of there's two basically categories of reason why the subject matter of a trust might be uncertain. The first is there could be basically a problem identifying the boundaries of the subject matter, and then there could be a problem identifying the actual property of the subject matter. So when we talk about boundaries, we talk about maybe how much there is. So there's Palmer and Simmons, where it was decided that a reasonable income, I think it was perfectly acceptable in terms of identifying the boundaries of the subject matter of a trust, because reasonable income could be determined by looking at the widow's previous standard of living. But saying the bulk of an estate, which could be anything from 51% to 90%, that was too uncertain. You couldn't have that. There is something important that you do need to remember about identifying the boundaries of a trust, which the subject guide touches on, so I think it's important to highlight, is the residue of someone's estate or the residue of a bank account is not an uncertain amount. And I think it's probably worth just explaining to you what a residue is, in case you don't know. If you do know, I apologise. When we talk about the residue of an estate, somebody's estate is the property that they hold, or just the property that someone holds, that's their estate. But we really only use the term when someone's died. And that's all of their rights of property ownership and maybe all liabilities if they died with debts outstanding. That's a liability on their estate then, rather than against them. And it's really common if somebody has enough property that they want to make a will to leave certain bequests and then leave the residue. So the residue is basically what's left of the estate after you've made specific gifts. So let's go back to examples of John and Mary and Jane, that was her name. Let's say John dies and he wants to leave Jane a gift of a property. Let's say he's a landlord of many properties. John wants to make Jane a gift of his properties because that's his sister. So he leaves her one house and he leaves the residue to his niece Mary. The residue means whatever's left. So maybe he owns 3 houses, he gives Jane 1, he leaves the residue to Mary. That means Mary gets 2 houses. And a residue, you can't say exactly what it's going to be because often there's liabilities on the estate when they die. Maybe there's a debt on the estate. And so the gifts are given out first, and then liabilities are often paid from the residue. So even things like funeral fees are paid from the residue. So you can't say exactly what it's going to be, but it's completely certain because it's not ascertainable at the time that the will is written, but it is ascertainable in general, that there will be a fixed figure that you can call the residue when certain steps have been taken, like all the debts have been paid, all the tax has been paid. That's really important to note. Do not, if you come across a problem question where somebody has left the residue of the estate or their estate in their will to someone, that is not an uncertain amount, because the residue just means whatever's left, and that is ascertainable, although it's not ascertained at the time that the trust is made. Ascertainable meaning you can work it out. So that's the problems identifying the boundaries of the subject matter. And then there's a problem, the other kind of uncertainty that comes under uncertainty of subject matter is identifying the actual property that's the subject of the trust itself. So this is where London Wine and Goldcore and Hunter and Moss all come into that line of case law, and you need to read those really carefully and remember that they've all come in for quite a lot of criticism. So it's perfectly fine to either argue for and against the law, but you need to know what those arguments are, and you need to think about them and how you feel you could formulate an argument around them. So London Wine was where there was going to be a trust. I think a wine company went insolvent. I can't quite remember. And the argument was whether you could have, if you had a trust of 3 bottles of wine out of a cellar of bottles of wine, whether that was certainty of subject matter, whether you could identify the property that was held on trust. Now, the problem with bottles of wine is that they might, even though some of them might all be the same brand, they might all come from the same vineyard, bottles of wine are different. One of them might have spoiled, for example. Is that the one that's being held on trust? If so, it makes the trust a lot less valuable. And if you can't answer those questions, which one of those bottles is definitely being held on trust because the settler meant for them to be held on trust, then you can't say that something is being held on trust. So something like, if somebody says, oh, I'm going to hold £100 in my bank account, that's probably going to be okay, because you can say, well, here is the £100, but if the bank account goes down to £50, then you might have a problem there, because you can't say exactly, or if the £100 was never in the bank account to start with, then there's no certainty of subject matter, because you don't know where this extra £50 are. So there's probably not going to be certainty of subject matter there. Now, the problem is with Hunter and Moss, you had a case of shares, and shares in a company, so you pay a certain amount of money, often nominal, and then people invest in the company, and they own shares which tend to be just a percentage of owning the company. And those shares give people voting rights for the board of shareholders, which gives them control over how the company is run. And in Hunter and Moss, there was a trust of shares. But again, you can say, often share certificates will have a number, so you can say, well, share certificate 1 to 5 is being held on trust, and then the rest of the shares are mine. But they are all interchangeable, and so the court, I think in Hunter and Moss, said actually what's happening is that the trustee who's holding the shares holds all of the legal interest of their shares, and they hold the equitable interest 95% for himself and 5% for the beneficiary or the other beneficiary. This has come in for an awful lot of criticism. It's not that helpful. And it's worth reading around why people feel that Hunter and Moss was not correctly decided. And you need to think really, what's the difference between, wine, bottles of wine and shares? Well, the obvious difference is the difference between fungibles and non-fungibles. Interchangeable property, like money, if you hold £10 on trust for someone, it doesn't matter what £10 it is, it doesn't matter what note it is, they're still going to have the same value, no matter what £10 note you give them out of a bank account of £100. And really that was the argument they were making with shares. It doesn't matter which 5 share certificates they get. it's still 5 share certificates and they're worth the same amount of money. Whereas wine bottles are different, because a wine bottle might have spoiled. If you drop a wine bottle on the floor and it smashes, is that one of the ones that was held on trust? You can't say. And that was why it had uncertainty of subject matter. And that is the analysis that some people apply. However, gold court was gold bullions. You figure one gold bullion is much the same as another gold bullion. So why wasn't that considered certainty of subject matter? That's the question I want you to think about. You need to be read the textbooks, read the commentary. They have different opinions about whether or not you can mesh those 3 cases together, and come up with a couple of your own opinions. I suggest writing out a couple of your own arguments. Sorry. Because that's the kind of thing that you can use in an essay, and it's something that's quite likely to come up in an essay subject.